Much and welcome everybody to this fifth seminar of the International PhD in Progress Seminar Series, Phase 5, organized by the Global South Network. I'd like to start this session by thanking the organizer of this series, Dr. Nauman Rayed. Thank you, lecturer in law in Leicester Law School, who is a founder and convener of this Global South Network. Myself, I am Dr. Laura Rhodes Saldaña. I'm a lecturer in law at the Faculty of Business Law and Social Sciences at Birmingham City University, and I will chair today's session. So a bit more about myself. After a period of practice as a corporate lawyer in an international firm, I studied at the University of Leicester for an LLM in International Commercial Law, and later a PhD, which I completed in 2019. As a Leicester alumni, it's always a privilege to chair this session. So thank you very much again, Nauman, for the opportunity. In 2018, I moved to Hertford College at the University of Oxford, where I was appointed as a stipendiary lecturer in law for 4 years until September 2022, when I moved to BCU School of Law as a lecturer in law. Generally speaking, my areas of expertise encompass company law, business law, corporate finance law, and law and economics, all of that particularly from an international and comparative perspective. Today, we are joined by 2 discussants and 1 peer commentator. Dr. Nicole Pierce as the first discussant for today's session. Nicole is a lecturer in law at the Department of Law at Goldsmith University of London. She's specialized in company law and commercial law. She's built a reputation in the Caribbean region, and she's an expert in various areas of law, including company insolvency, issues related to regional integration, and she has also worked for the World Bank, Inter-American Development Bank, the Caribbean Community and Common Market, and the Organization of East Caribbean States. Nicole currently leads projects in various areas of commercial law reform in the CARICOM and OECS region. Dr. Horace Yeung, he's an associate professor in Leicester Law School at the University of Leicester, and he will be the second discussant today. Horace's research interests lie closely with the teaching he's doing surrounding commercial law. His research has a distinctive global comparative and interdisciplinary approach, especially underlying the role of law and economic development. He's a member of the expert group of the Legathem Institute London and leading UK think tank in the compilation of the Global Prosperity Index, alongside eminent fellow experts, including former central bank chiefs and economists. Next, I would like to introduce Gabriel Sauber. Hopefully I'm saying this right, and he's the peer commentator for today's session. Gabriel is a graduate of the University of Lagos. After being called to the Nigerian bar in 2018, he worked as a legal associate in a commercial law firm in Lagos, Nigeria, before joining the University of Aberdeen for his LLM. where he excellently majored in international commercial law. His sterling performance contributed to his being awarded a PhD merit scholarship by the Faculty of Law at the University of Aberdeen for his doctorate research, which focuses on developing legal standards for electronic trade and trade financing, with special focus on electronic letters of credit and electronic trade documents. Gabriel has a background in philosophy and education as well, and is a qualified arbitrator, mediator, and teacher. Last but not least, today's guest speaker is Ruijue Gu, who is a second-year PhD candidate at the Leicester Law School at the University of Leicester, and their research focuses on the letter of credit. Today, Ruijue will present a comparative analysis of letter of credit in the UK and China. So whenever you are ready, you have 30 to 35 minutes for the presentation, okay, which will be followed by 5 minutes for comments or questions from each discussant, and then the peer commentator, another 5 minutes, and then hopefully we will be left with 15 minutes at the very end for a Q&A from our attendees. If that makes sense, okay, whenever you are ready, the floor is all yours.
Yeah, so good afternoon, everyone. I'm so glad to be here and to share my research. And my research title is The Beneficiary's Right to Obtain Payment on the Letter of Credit with Special Reference Law and Parties with China and Selecting Anglo-American Jurisdictions. First of all, about me. My name is Ruijue Gu, and from China. I'm a PhD candidate in School of Law, University of Leicester, and my research interest is about letter of credit under the international transactions. And for this presentation, I just divided it into 4 parts. First is the background, then the research question. The third one is the research design, and finally, the research originality or the research gap. Firstly, about the background. Let's take a look back in the time of our childhood. Let us suppose you have a friend with whom you hang out pretty often, and one day you have to buy something from the classmate who doesn't know you but is a friend of your friend. So your friend voucher for you and take guarantee for you that you will pay them another day. That is a strange example, but that is the letter of credit all above, and we will discuss more about it in the following lines. Letter of credit can be recognized as the most widely used and prevalent payment methods in the international trade. Due to its extensive utilization, and it has been referred to as the lifeblood of international trade and commerce. Letter of credit is a financial document applied by an importer to the bank to guarantee payment from the exporter after the specified requirements are met by the importer. An example might make it easier to understand. As shown in the diagram, in the process of a letter of credit transaction, there are 4 parties involved, respectively, the buyer, which is also known as the importer. The seller can also be called as the exporter or the beneficiary. Issuing bank, its customer is importer, and the nominative bank in most situations is the exporter's bank. Firstly, let's suppose B, an exporter from China, has a contract with A, an importer from the UK, for sending a shipment of goods. Both parties, being unknown to each other, decide to go for a letter of credit arrangement to minimize the risk. From this point on, this is how letter of credit transaction would unveil between A and B. After A and B sign the sale contract, A, the buyer, goes to his bank and issue a letter of credit. When the issuing bank receives this application, it further processes the letter of credit to the nominative bank. And the nominative bank checks the authenticity of the letter of credit and sends it to B. Now, B has received the notification or the confirmation of the letter of credit. Then he will ship the goods. And while doing so, he will receive a bill of lading along with other necessary documents. Next, B will send this relevant document to the nominative bank. And the nominative bank then will make sure that all necessary requirements of the letter of credit are fulfilled and accordingly make the payment to B, the seller, or the beneficiary. Additionally, the nominative bank will send all the necessary documents to the issuing bank, and the issuing bank will send to A, the buyer, to confirm the authenticity, Once A has confirmed, he will make the payment to issuing bank. Then the issuing bank will transfer the payment to the nominated bank. In this letter of credit, it ensures B that he will receive the payment from the buyer A and assure A that he will have the systematic and documented process along with the evidence of the goods has been shipped. As an agreement between importer and exporter and their banks, letter of credit is against potential payment failure and mitigates various risks associated with cross-border transactions, such as the default risk of the importers, political policy of the importing countries, and so on. Cross-border trade is more risky than domestic trade, because trading parties may have different official language, or are in different countries or legal jurisdictions, and the transit time is very long. By using the letter of credit, the exporter can transfer the risk of default of the importer to the importer's bank. Once the exporter meets the requirement of the letter of credit, they have the right to claim the payment from the bank, which reduces the risk of non-payment in cross-border transactions. The above is the ideal situation. All parties fulfill their duties. However, my research focuses on whether the beneficiary has the right to get payment when one or more parties breach their duties. For instance, if the document presented to bank is forged, but the beneficiary is innocent, should the bank make the payment or not? Or some relevant clauses are put in the letter of credit or sale contracts. Will this affect the beneficiary's right to get payment? If the beneficiary is recklessness, enable a third party to prepare to present documents fraudulently, should bank honor the credit? Then, as for my research questions, there will be 4 of them. The first one is, what is the position of beneficiary when seeking payment on the letter of credit in China and selecting Anglo-American jurisdiction? The second is, what is the impact of autonomy principle on operating of letter of credit in the selecting Anglo-American jurisdiction and China? And to what extent may clauses in the letter of credit or the underlying contract affect performance of the bank's obligation to honor the credit and the beneficiary's right to get payment? The last one is, what is the position of bank where document presented to bank is forged and the presenter, the beneficiary, are innocent, compare China and the selecting Anglo-American jurisdictions? And for the third part, as for my methodology, this research will use doctrinal and comparative approach. The doctrinal method is normally a 2-part process, which involving identification, the source of law, and then interpreting and analyzing the legal content. This research will utilize a comprehensive literature review to conduct a comparative analysis of legal provision and case law across different jurisdictions. To examine China and selecting Anglo-American jurisdiction law, the research follows the doctrinal study, which aims to analyze primary source, such as legislation, the case law, and the secondary source, such as the textbook, journal articles, and also some useful official websites. Through this analysis, it aims to evaluate the impact of the letter of credit payments in the different jurisdictions and propose appropriate solution for it. Besides, this research also including a comparative approach to analyze the legal framework and the practical implementation of payment on the letter of credit. A functional comparative approach will be used, which focuses more on the practical problem and how each jurisdiction address that problem. This study will compare the legal system of China, the United States, the United Kingdom, and Singapore on letter of credit, and the solution on relevant issue. This study will examine Chinese law to determine how it deals with letter of credit payment issues and the resolution and the solution of it. It will also analyze the legal system of the remaining 3 countries and their solution to such problems. Finally, after comparison, it is determined which of the different legal system or jurisdictions with the same purpose can solve the problem more efficiently or more appropriately. And for the reason I choose China, UK, USA, and Singapore as my comparative research object is that I come from China and I'm familiar with Chinese law and found out there are some issues in letter of credit and want to figure it out. However, I cannot solely use Chinese domestic law to solve the problem. So I have to make a comparative study with reference to the experience of other countries' legal system. For choosing USA as one of the objects, it's because some Chinese case law and regulations has been influenced by the US president and also Uniform Commercial Code UCC Article 5. Besides, the English law has a strong influence in common law system, especially on issues relating to the letter of credit. Furthermore, as for the Singapore, recently it handled many case law related to the letter of credit, and I can get some latest update or information from it. As for the originality of my research, I currently focus on my research question number 3, and focus on the challenge and the dilemma that the bank may face at the stage of payment in the letter of credit, especially when the credits including the non-documentary clauses. And the uniform custom and practice for documentary credit, which is referred to UCP, is a set of rules agreed upon by the International Chamber of Commerce, referred to ICC, that is applicable to any documentary credit. It is generally recognized the legal source of letter of credit. UCP 600 was established in 2007, and it is the latest version. Although National Court often referred to UCP 600 as a guidance to interpretation and banking practice, the UCP 600 did not become an independent source of law, rather than a standard set of contractual terms or conditions. Hence, UCP 600 can only be applied to govern the relationship under the credit when both parties agree to incorporate UCP 600 as expressly stated in the credit. Article 5 of UCP 600 states that one of the basic principles of documentary credit is that banks only deal with the documents and not the goods, service, or performance to which documents related. Moreover, in order for more trade to be completed and to reduce the time required to complete these transactions, Article 14H of UCP 600 provides that if a credit contains a condition but does not stipulate for a document indicating compliance with the condition, the bank will regard that condition as non-state and will not consider it. Such condition is generally referred to as the non-documentary condition. The root cause for non-documentary condition in the credit can be traced back to when the credit was issued. The most of credits are issued on the instruction of the customers. They may contain trade terms which may not be specific. Moreover, if the official language of two parties is different, or the banker is not familiar with the relevant business, or lack of experience, the banker could not identify or clarify the exact meaning of the condition. Besides, if the issuing bank does not carefully review the credit application form, the bank is not able to amend it before issuing the credit. All above elements can lead to the appearance of non-documentary condition. As for the lifeblood of international trade and commerce, the core role of the credit is to ensure that the beneficiary can obtain timely payment from the bank after presenting documents in accordance with the credit provisions. However, in practice, some of the credit contain the non-documentary condition. The beneficiary may encounter some problem when presenting document to get the payment. For example, one condition in the credit states that the ship on which the goods are to be delivered by the beneficiary must have never been in an accident during the sea transport. However, this provision does not regulate documents indicating compliance with the requirements. Thus, after presenting the document without providing any relevant evidence to prove no accident happened, the beneficiary may not get the payment because the bank may refuse to pay, based on the reason that the document presented did not fulfill the requirements in the credit. So, how should bank respond when faced with this non-documentary condition? The two main legal sources of credit give contradictory guidance, putting bank in a dilemma. The bank can either follow the guidance provided by the President, or it can apply the Article 14H of UCP 600. Firstly, as for the guidance provided by the President, the case law as an alternative legal source of credit hold that the bank must ensure that the documents exempt complying with the requirement of the credit, and that any non-compliance is at the bank's own risk. In the missing line case, the credit in question contained a non-documentary condition that stipulated the goods shall be shipped on a vessel of a shipment company that is a member of an international shipping company conference. However, this condition does not specify the document to be presented to prove that the requirements are met. The confirming bank gave the reason for refusing the beneficiary to honor the credit. That is lack of company certificates proving that the ship belongs to the member of the International Shipping Company Conference. The above reason for non-payment effectively transformed the original non-documentary condition into the normal documentary one. The confirming bank expressly stated that the reasonable document is needed for the beneficiary to present to meet the non-documentary condition. That the beneficiary presented the required documents before the expiry date of the credit, that effectively obtained the payment. In this situation, Judge Parker held that the bank had an obligation to ensure that the non-documentary condition was met. Since the bank only deals with the document, the bank has the right to require the beneficiary to provide reasonable documents to prove that the condition specified in the credit are met. But Sir John Donaldson thought this outcome was unfortunate for the bank. The ruling required bank to determine what documents are sufficient to show that the non-documentary condition has been met. In this situation, although the magnitude of the problem is not apparently in terms of non-documentary condition, however, if more complex cases are involved in the future, the bank may be asked to determine which documents can prove that the non-documentary condition of the credit is met. That may put too much pressure on the bank. On the other hand, in 2017, UCP 600 was published by International Chamber of Commerce. Under Article 14A of UCP 600, the bank's obligation is to examine only the document presented to see if they are in conformity with the provision in the credit. For example, if the buyer requires the origin of the goods to be in China, but the banker does not find document to prove the claim, the bank may not reject payments on the basis of the documentary discrepancy. The absence of document to confirm whether the origin of the goods is from China does not mean that documents presented are inconsistent with the credit. To prove the inconsistency, there are two objects required: the condition and the document presented. However, the beneficiary has not presented any relevant documents. Hence, it cannot be proved that there are no inconsistency. In practice, once the bank accepts these uncertain documents, he is responsible to the buyer, and the risk is transferred from the beneficiary to the bank. To avoid this risk, the bank probably will reject the document. Therefore, the most straightforward way to solve this problem is to simply ignore this condition by applying Article 14H of UCP 600. However, Article 14H of UCP 600 is under some restrictions. For example, Article 14D, and also the ICC in Banking Committee Opinion R631 state that the data on the document presented must not conflict with the data in the credit. Moreover, Article 14H is restricted by the paragraph A26 of ISBP 745. The provisions state that the data contained in the document must not conflict with non-document condition. For example, one condition in the credit states that the ship on which the goods are to be delivered by the seller must have never been in an accident during the sea transport. Although there is no requirement for documents showing compliance with the requirement, any evidence of an accident on the cargo ship in a presented document would be considered a data conflict. then the bank has the right to refuse to make the payment under the credit. However, in practice, will the direct application of Article 14H of the UCP 600 lead to another knock-on effect for the bank? There is a point of view that the bank direct application of Article 14H of the UCP 600 is a wrong decision. The problem lies in the contractual nature of the credit and the fact that the UCP 600 stipulates its term can be revoked. Article 1 of the UCP 600 states that this rule applies to the credit and are binding on all parties unless the credit is expressly modified or excluded by mutual consent of the parties. Since the UCP 600 is incorporated into the credit by reference, the express term of the contract, especially the non-documentary condition, overrides the rule of the UCP 600. According to the principle of the interpretation of contracts, in other words, express terms take precedence over those incorporated into the contract by reference. And Article 14H was initially welcomed by the bank as easing the pressure on them to make their own judgment to choose reasonable documents and maintain the independence of the credit. However, it put the bank in a dilemma. Although the choice is the bank's, it can choose either to apply Article 14H of the UCP 600 to ignore the non-documentary condition or to follow the guidance provided by precedent. However, if the bank chooses to apply Article 14H of UCP 600, the applicant of the credit may make complaints against the bank for the beneficiary's failure to present reasonable documents that fulfill the non-documentary condition. Or, if the payment is refused by the bank because the bank follows the precedent and rejects the documents presented by the beneficiary because of inconsistency, then the beneficiary will make complaints to the bank against this refusal. And I'm currently focused on the English law system. I will go deep into it and find relevant article in United States legal system and also the Chinese legal system to find the difference and similarity in these issues. And in the final part of this chapter, I just plan to do a comparative study to make a conclusion what is the best or the most appropriate solution for this problem and what can each jurisdiction learn from each other. And here's my research. Thank you for listening, and any question? Yeah, thank you.
Thank you very much, Ruijue. Thank you for this fantastic presentation. So now, without further delay, if you like, we can move on to the discussions. It's my understanding, Nicole, that maybe you would appreciate going fast, right? That you need to be somewhere else earlier.
Yes, I have time.
Yeah. So please, whenever you are ready, 5 minutes.
Okay, I'll be very judicious with it. This is a very interesting topic. I actually have drafted, and dealt with letters of credit. I'm originally from Jamaica, an attorney from Jamaica, a commercial lawyer from Jamaica. So we're big into shipping. The interesting thing about this is that your research is leading to many questions in my mind, which is a very good thing. Okay. And from one standpoint, you've picked 3 common law jurisdictions to compare with China. And so the one question that I was led to was, what was the rationale? I understand Singapore because you have some experience with that, but the selection of the US and the UK, that's one thing. And then it led me to another question. Well, what would have been how would this have been handled under civil law, a civil law jurisdiction? Okay, because China certainly does a lot of exporting to the EU. So that's on the one hand. In relation to your analysis, excluding the UCP 600, which has to be stated in the contract itself, which would, a lot would exclude it. The one thing that is very important to common law jurisdictions is certainty of your terms and sanctity of contract. and I'm also a contract lawyer, and I teach contract law. And to me, if a bank is faced with this dilemma on, say, ambiguity as far as requirement proof of a term, is this term a major condition of contract or a minor condition of contract? Okay, and from that standpoint, if proof of that the vessel has been in any accident during its duration of travel, if you've got a clean bill of lading that's been issued when the goods were loaded onto the ship, then that's what's guiding the transaction and any recovery if there's any damage to the goods. The payment, it led me to the question is, what type of payment is this? Is this an irrevocable letter of credit? If it's an irrevocable letter of credit and you have ambiguity as to a term of whether the ship was in an accident during, its travel to its final port of destination before it unloads, is irrelevant to the irrevocable letter of credit. The irrevocable letter of credit is an undertaking by the bank that they will pay upon presentation of the documents. If there is a condition in there that has not been stipulated, it's going to get thrown out, okay, for ambiguity. There's going to be a rectification of your terms, and that's under common law. In relation to the UPC, it seems to be replicated in the UPC, giving the bank the authority to ignore this. But this is under an irrevocable letter of credit. If you're talking different forms of letters of credit, you may run into some issues with that, but I just think your topic is very, very interesting. The aspect that's really important is the issue of fraud, because the more countries that are turning to China to buy goods, all right, it's very important that you have protection of your payment system, and letters of credit is the way to go. Because of the lack of familiarity between buyer and seller and the need for certainty as to payments. So in that instance, I mean, beyond my question about civil law, how would civil law handle this? And if the UPC 600 is excluded as a contract term, then you're reduced to content of case law. So that was my comment. You left me with a lot of questions, a very interesting topic. But I do think you need to clarify, from my standpoint, what type of letter of credit you're talking about, because there is a whole myriad of them. And on top of that, its presentation with the bill of lading and the related documents are very, very important. What type of, what type of shipping term was used? Incoterm. What type of Incoterm was used? It leads me to these questions. But that's something you would flesh out in your research. But thank you very much.
Yes, thank you so much. The comment will help me a lot, because I just got some idea to fulfill in my research. I think I still have some gap in this particular area. So I just, after this seminar, I will just go back and to do some research about that. It's so helpful for that. Yeah.
Civil law is very, very important, because their terms on creation of contract are there's a huge dichotomy between civil and common law. And so, formation of contract is really interesting. And I would also, anyway, it leads down to a whole other avenue. But thank you.
Yeah, thank you.
Thank you very much for the depth of these questions and these comments, Nicole. That is very, very much appreciated. We all do, and surely Ruijue does as well. Thank you so much. So now we would move to Horace, whenever you are ready as well for your discussion. The floor is yours for the next 5 minutes.
So I have to first give my caveat. So as a sharp contrast to Nicole, who has experience in drafting letter of credit. So my expertise is more about company law, but I can't say I know nothing about letter of credit. So because I'm on the teaching team of commercial law in Leicester, and then we do teach the use of letter of credit. So on our commercial law part 2 in the second term. And then also for my PhD students, so not Laura, because Laura's PhD is not on letter of credit. However, So I've also supervised, actually supervised a student with a band, so your supervisor. So the student is Tajuddin. So Tajuddin has completed a PhD project about a comparative study of letter of credit. So the jurisdictions that he has compared is Libya, Egypt, and also the UK. And then also other than Tajuddin, so who has already completed. So I'm also supervising another PhD student from Cyprus, Rafaela. I think you may know the name of her already. So her project is actually quite akin to yours. So that will be all my experience in relation to a letter of credit. So I agree with you and also Nicole that so it's obviously an important topic. I think as you have quoted in your slide, so it's regarded as lifeblood of international commerce. So it's also a very complex matter. So as you have demonstrated in your diagram, so we have the buyers, and the buyer will apply for a letter of credit from the issuing bank. And then on the other side, so we have the confirming bank, and then also the seller as the beneficiary. And then depending on the capacity that the bank is performing, then we have different names. So issuing bank, confirming bank, nominated bank, as also advising banks and so on. So you can see that so there can be a lot of stakeholders involved, and then so it's a complex issue. So the key principles that you have highlighted in your slide will include, for example, autonomy. So the idea of autonomy is so the letter of credit agreement will be quite separate from the sale of goods agreement. So for example, so even though the goods are in terrible shape, and then even the ship is sunk and then the goods are lost at the sea. So as long as so there is a complying presentation, so the bank actually should pay up. So I think there is a practical dimension to this autonomy principle, because as a bank, so what they can do will be to see the documents only, to inspect the documents. So it is very difficult for them to play a detective role and then to really to go to the port and then to inspect the condition of the goods, because it's just not possible from the perspective of the bank. And then other than the autonomy principle, you have also pointed out, so we have principle of strict compliance. So in principle, so we expect, if possible, a 100% complying presentation. But of course, we have leeway. So both according to the UCP 600 as well as the case law as well. So I would say so letter of credit is so important in the sense that so to the buyer, so it's a form of credit. So sometimes you may not have the money at the end, so you can get the credit from the bank through a letter of credit. And then for the seller, so it provides a form of assurance. So as long as you have fulfilled your obligations, then you would be quite safe to know that you will get the payment. And then also to all the parties, so there's also a degree of certainty. So I think just like as indicated by Nicole, so there may be discrepancies in the approach between civil and common law. But at the end of the day, it's a standardized form of contract, and then which is harmonized by UCP 600. So as a result, so as long as you are in international trade, so you will get some sense of so how the whole thing will operate. So in terms of, as I have said, so although it gives the seller, the beneficiary, some assurance, however, there may still be some possibilities that so the seller may not get payment. I think one option, one situation would be, so it's a non-conforming presentation. So if you have ordered English breakfast tea, and then on the bill of lading, it just say English tea or breakfast tea, then that would give every reason for the bank to refuse payment. And then some other exceptions to the assurance of payment will be in the form of, for example, fraud as well as illegality. So that may be something that perhaps not covered by the UCP 600. So that may be subject to the case law of different countries, because so the notion of fraud may not be the same across countries like US, UK, Singapore, as well as China. The same for illegality. What is legal in one country may be illegal in another country. So that's why I think we cannot rely on UCP 600. So that's why we do have to look at the case law. I think in relation to the difficulties in conducting research on this topic would be, so I think one thing would be, so it's sort of harmonized by UCP 600. So I would say there may be more consistencies and similarities rather than differences. But of course, so it's down to you as a researcher to try to unveil as many differences as possible. And then a second difficulty, as far as I can see, so with my experience in supervising 2 PhD students on the topic, it will be, so although it's an important topic, so I can't say there is a very large body of literature on it. So again, it's down to you as a researcher to try to unveil as many relevant literature as possible to enrich your thesis. And then, so quite like what has been indicated by Nicole, so I do have some opinions. You can call it a critique, but I will say some view regarding your comparative methodology. So one point would be, so you are comparing 4 jurisdictions. So if you still remember what I said in my comparative law training, so apparently in the comparative project, the magic number is always 3. So if you compare 3, then that would be the magic number. If you compare 4, that may be a little bit too much, but at the same time, of course, so why not? So if you think that, so we do have to look at these 4 jurisdictions. So it's possible to push the boundary a little bit, so to look at 4 jurisdictions. And then, so one thing about this comparative law methodology would be, so of course, you are from China, you know the language, so you know how to read Chinese. However, so for some other jurisdictions, so especially the USA, so I get a sense that so there may be some practical difficulties for you, because for Singapore, you can get the help from Ben, because Ben did his PhD in Singapore. And then for UK, I'm quite sure all of us here will know how to find cases, so in relation to UK. But for USA, then I think you may need to ensure that you try to see how you can find all the materials in respect to USA. Although they have a UCC, they have a law across all the 50 states. But at the end of the day, so for the case law, then they have 50 jurisdictions. So I think you may need to get some advice, guidance to see how you can get the resources in the USA. And then I think my final point about, I think quite like Nicole. So you do have to think about, so why do we need to look at these 4 jurisdictions? So are you trying to draw on the common law experience for the benefits of China? But then there can be a problem, because so China is not a common law country. So how can they draw on the case law in common law jurisdictions? I think that can be one problem. And then a second problem would be, so if you are trying to compare civil and common law, then I think the choice of jurisdiction is a little bit weird, because so 3 of them are actually common law, just 1 of them civil law. So as a result, then I can't say it's wrong to compare these 4, but however, make sure, so in your very first chapter in your thesis, so you must justify very clearly why you choose these 4 jurisdictions. I think that's it I want to say. So a little bit too much, but hopefully I think we still have time.
Yes, thank you so much for the comments. I will just modify my methodology after this seminar, and just reconsider the rationale I just chose this 4 jurisdictions, and just make the balance when I just do my methodology is 1.
No need to change anything, but just make sure you explain this choice very carefully and clearly.
Yeah, thank you. Thank you so much.
Seconded, Horace. Thank you very much for your very thorough discussion at this point as well. Thank you. And now last but not least, right? Gabriel, the floor is yours now for the following 5 minutes. Thank you.
Thank you very much, Laura, and thank you for a wonderful presentation, Gu. Let me start by saying that your presentation was really wonderful, and it was easy for me to follow and understand everything you said. And I think that one positive I have to mention with regard to your presentation and your topic is that it's interesting that you are bringing China into the discussion of letters of credit, which you don't often find in most textbooks on letters of credit. So for my background, I wrote a PhD thesis on the presentation of electronic trade documents in electronic letters of credit. So I've been able to grapple with some of the literature in this area. And a few points, peripheral points, before I make around 2 substantive points. So the very first thing I want to say is just to echo the sentiments of Dr. Nicole and Dr. Horace with regards to the rationale for the choice of the jurisdictions you are examining. So first of all, the first thing to say about it is that even though in the substance of your presentation you mentioned 4 jurisdictions, that is not reflected in the topic. The impression your topic gives is that it's just between the UK or England and China. Perhaps you need to reconcile that. It's either the topic reflects the wider coverage of the comparative analysis, or just think about that. But speaking more specifically to the rationale for the choice of these jurisdictions, obviously, you know that China is not in the same legal family as some other jurisdictions you are comparing them with. So it would it needs proper justification. But I think that there are things you can say that would bring them together. For example, the fact that if you look at the WTO statistics, China is very prominent with regards to trade volumes, also prominent with regard to trade revenues, and especially in contemporary times. So that could also be one of the justifications somebody can give to bring it to the discussion. But just, I think it's not enough to just say that you are from China, and that's why you are interested in it from the angle of China. So these are the few things I want to say with regard to the peripheral concerns. Then to the more substantive concerns I have, you are dealing with the problem of the non-documentary conditions and how they affect the performance of the obligation of the bank with regard to examination of these documents and payment to the beneficiary. And from what I see from your presentation, it's as though you are looking at only the non-documentary conditions that appear in the contracts between the parties. I want to extend the discussion also to some of the non-documentary conditions that might appear in the context of payment. And some of these non-documentary conditions may not even be in the contract. I'll give you an example. Banks. As a result of the problem of money laundering and terrorist financing, banks are under obligation to respect some of the regulations that have come out in order to enforce anti-money laundering as well as anti-terrorist financing. And because they're under obligations to do this, when the banks are presented with documents by the beneficiaries, apart from looking at the documents to see whether or not it complies with the terms of the credit, banks are as well expected to look at whether or not this transaction is a kind of transaction that breaches the anti-money laundering regulations also. So how does that relate to the operation of the principle of autonomy? How is this challenge? How is this balance, seen in England and in these jurisdictions you are looking at? Maybe you may want to look at this because it's also one of the it's not in the document, but obviously the banks are called to look at these regulatory compliance issues. Then the last thing I want to say with regards to your presentation and your topic is maybe you need to think also about the justification for the topic. An examiner can ask you, why are you even interested in letters of credit at a time like this? Maybe some years back, wonderful, but maybe now there are people who are arguing that letters of credit, that it's a diminishing instrument, because as it is today, people say that it's very costly for SMEs in so many developing countries. That as a result of documentary intensity, use of paper documents, it leads to a lot of delay and a lot of problems, and therefore that so many trade parties are going to other open account trading alternatives as a result of supply chain finance techniques. So this could be something you may need to think about, the justification for the choice of the topic itself. So why are you interested in letters of credit? Do you think it is still important in the world of today? But apart from that, I think you've presented a very wonderful topic, and I really enjoyed it. Thank you.
Thank you so much. You just bring some new idea about my research, and I would just consider the money laundering aspect. I just never thought of before. It's a very good idea, like a good new idea for my research. Thank you so much for the suggestion. Thank you.
Okay, thank you very much. Thank you, Gabriel, as well, for this very, very insightful comments for Ruijue. Thank you. Thank you very much. So, fantastic. We have 6 minutes left, okay? I open now the floor for any questions that anybody may have. So please, if anybody has any question, myself then, a very quick one before we conclude, okay, Ruijue? So as Horace said, my background is as his more in company law, but I happen to have exactly the same methodology as yours in my PhD thesis. So it was identical, it was doctrinal, and it was a functional comparative approach. And there were some things that I just want to comment a bit. You might have thought of them, but otherwise food for thought, okay? Things that I encountered that I think might be interesting. Particularly when we are talking about the combination of these two methodologies, it's important, I found, to justify the combination of both, right? Because you are dealing with an issue that is that it will vary, right? So the common law will continue an evolution of it. So the doctrinal approach, when you are just analyzing case law and primary sources, secondary sources, that will keep on varying, right? And some people will ask you at this point, it might be interesting for you to see case studies, right? So not only things that they actually end up going to court, but is it working for them, right? So what would be very interesting is, are people using letters of credit? A little bit aligned with what Gabriel was saying, right? So these are questions that I think you are likely to encounter. So what's the reality of things, right? So not only what are the problems that they are brought to court, but what's the reality of things, and particularly since you are choosing to go for a functional one, right? For a functional comparative approach, you will want to at least have an idea of the justifications of what is the reality behind all this theoretical approach that you are bringing forward, okay? So not a criticism, just food for thought, but because this is something that I found very useful when I started thinking about it, okay?
Thank you so much for this one. Yeah, thank you.
All right, no problem. Then thank you very much, everybody. If there are no questions from the floor, I will just conclude this session. Thank you, Ruijue, for an excellent presentation on the letter of credit. Many thanks as well to Horace, Nicole, and Gabriel for their very useful and insightful comments. Thank you so much. Now, just a reminder that the Global South Network does warmly welcome PhD students from any discipline and any part of the world to share their projects and receive interdisciplinary feedback. Anybody interested in presenting their work or participating in a session, either as a peer commentator, chair, or a discussant, or giving feedback on the network's activities, can contact Dr. Noman Bardrayat, who is the founder of the Global South Network, and his email address, if it's not there yet, we will pop it in the chat. Here you go. There it is. Fantastic. Thank you. So again, same time next week. this seminar will meet the next guest speaker, Yeung Lu, a PhD candidate in the School of Law of Queen Mary University of London, who will present a project entitled Blurred Boundaries of Authorship, a critical inquiry into artificial intelligence generated creative outputs. This will be, to be sure, next Wednesday, the 12th of February, 2025, from 3 to 4 UK time. Until then, take care, look after yourselves. Very nice seeing everybody, and thank you again. And thank you for having me too.
Thank you very much.
Thank you.
Thank you. Have a nice day. Bye.
Thank you,
Have a nice
everyone.
day. Yeah, bye-bye.